Morning in America. Yesterday, David Rivkin was on, and he helped everybody understand what was involved in the first day's discussions at the court. There was another discussion yesterday, and David is back with us. He's a partner at Baker Hostetler. He used to work in the Justice Department, the White House counsel's office for Ronald Reagan and George H.W. Bush. Good morning, David.
Great to be with you.
Thank you very much for coming back. DOMA. What is DOMA in its most important way, and the way that shaped the discussion yesterday? And what did we learn, and what could we predict from what happened yesterday?
Well, was an issue yesterday's Section 3 of DOMA, which is Defense of Marriage Act, which basically states that some 1,100 federal statutes that use the word marriage for a variety of purposes, Social Security benefits, tax benefits, construe marriage, or the term marriage should be construed to apply only to traditional marriage.
1,100 federal statutes.
Right, only federal statutes.
Okay.
And what was an issue is whether or not Section 3 of DOMA is constitutionally objectionable. There, aside from the debates about standing, because the Obama administration, in its typical fashion, played a very strange role here. There was a statute passed by Congress. They were supposed to defend it. They defended it for a while. They stopped defending it. They were still complying with it. And the way they defended it or behaved in court was very strange. They actually were trying to get the court to overturn that section. So you had House of Representatives appoint its own lawyer, Paul Clement, who participated on their behalf in defending the constitutionality of that provision. So you had lots of debates about standing, and then you had debates about whether or not this provision, Section 3, was consistent with federalism, which is to say whether or not the federal government has any legitimate interest in marriage-related issues. Definition of marriage, of course, being the province of states.
Well, if there are 1,100 statutes relating to marriage at the federal level, I would say at least the federal government thinks it has some standing.
Absolutely, and that was the key underlying argument, that we're talking about statutes that reflect significant federal interest. All those statutes were passed at the time marriage. This was prior to the advent of same-sex marriage. All those statutes reflected congressional desire that they apply only to traditional marriages. Plus, the federal government, Bill, and it's very important, a lot of discussions about uniformity. Because, look, you have very strange situations. What if you have a gay couple that's married, for example, in Massachusetts, and if the federal government would have followed the state definition, and let's say they filed their tax return as a married couple, but they moved to Texas. Texas does not recognize same-sex marriage. So does it stop? What if we move back to another state that does? What about people in the military? What if you're serving one military base in a state that recognizes same-sex marriage, and then you move to another one that doesn't? And in fact, you're moving there not because of your own will, which is a little different from my first hypothetical. You're moving there because the government has sent you.
Does DOMA say that marriage is between a man and a woman, or does it just assume that, or something else?
It says so, and that was relevant to the discussion, of course, of whether or not this reflected a rational judgment by Congress that deserves recognition by the court, or reflected some animus.
Now, when Justice Kennedy was speaking yesterday, most people interpreted what he was saying as being suspicious of DOMA itself.
Only on federalism grounds. I have to say I disagree with Justice Kennedy. I think DOMA is perfectly defensible on federalism grounds. But on the other hand, he clearly was only interested in this issue. Kennedy is the most articulate voice of federalism in the court today. As you may recall, he played this role during the Obamacare. So he just felt that, and it's very important, the reason I mentioned 1,100 statutes, he just felt that when the federal government, for purposes of all of its statutory law, this is the sort of the best way he put it, all those statutes provide for multiple interactions, daily interactions with the life of every citizen in this country. The federal government steps out in favor of traditional marriages. It puts its thumb, I'm slightly paraphrasing, on the scale too much. In effect, it makes it more difficult for the states to move in this direction. Now, with respect, I think that he is wrong for a simple reason. The federal government has no choice, Bill. The federal government has to put its thumb on the scale somewhere, because if it were to adopt the definition of marriage following state law, that would, in effect, suggests that they're more sympathetic to the 9 states by now that go in that direction. So that's why it's one of those difficult situations where the best federalism solution is when the government goes with the majority of the states, plus the really insurmountable problems with the uniformity issue, again, with people moving back and forth, government employees in particular.
All right, something here I don't understand. We have to backtrack a little. Let me play a little bit of Kennedy on this point. I think it's on this point, and then ask you to explain it in a specific question I'll have. Go ahead. Cut number 1, Claude, please.
I think there's quite a bit to your argument that if it's a tax deduction case, which is specific, whether or not if Congress has the power, it can exercise it for the reason that it wants. That it likes some marriages, it doesn't like, I suppose it can do that. But when it has 1,100 laws, which in our society means that the federal government is intertwined with the citizens' day-to-day life, you are at real risk of running in conflict with what has always been thought to be the essence of the state police power, which is to regulate marriage, divorce, custody.
That's exactly, Bill, the passage I was talking about. What Justice Kennedy seems to be suggesting, the federal government adopted for its own purposes, and what we're talking about again is federal statutes, for its own purposes, the traditional definition of marriage in a few statutes, he would have less of a difficulty with it. But because it's done across the board, the time DOMA was passed, it really, in effect, covered the whole federal statutory waterfront. He thinks it squeezes the states a little bit, squeezes the states in the area, namely the definition of marriage, that is at the heart of state police power. He's making quintessentially federalist argument. As I mentioned a couple of minutes ago.
Wait, let me interrupt. But before DOMA, you had 1,100 laws, regulations.
I mentioned the word marriage without defining it.
Right, but he didn't have any problem with that. It's only when DOMA appears that it appears to be strangling the state.
Because of it, before DOMA was enacted, of course, not a single state. Before 1996, and Hawaii Supreme Court moved in this area, no state has recognized same-sex marriage, so there was no problem.
Okay.
And if you had the same situation today, you would have no problem. On the other hand, you have now states going in 2 different directions. He is suggesting that the federal government, by adopting a traditional definition for its own purposes, is interfering a bit, given its sheer heft in a modern administrative state time. My problem with that argument, which is, again, is very respectable, I take federalism enormously seriously. That was at the heart of our challenge to Obamacare. The problem is the federal government has no choice, Bill, because the federal government basically tracks the state definition of marriage. It is implicitly suggesting, and explicitly in a way, that changing the marriage going to the same-sex definition is perfectly fine with it. So, in effect, it would be given a leg up to the 9 states. So there is no third option here for the government. So the combination of trying to, for the sake of federalism, side with the majority of the states, plus its own uniformity interests, which I can spend 20 minutes telling you about all sorts of weird situations that would arise because of people moving back and forth among different states. I think he's wrong, but again, I think his posture is respectable. One thing to underscore for your listeners, again, what did not happen yesterday, not a single justice evidenced any interest in the broader, more far-reaching arguments about same-sex marriage that were also in play the day earlier, including 4 liberal justices. They're all talking about federalism. They're all with Kennedy was genuine, Bill. With the 4 liberal justices, I think it's a little bizarre given their position again in Obamacare and other cases where federalism was important. Yesterday, everybody in the court was a federalism. Federalist.
All right, good. I wanted to ask you about that. The more, because I said this the first hour as a guess on my part, but it seemed to me the more rhetoric, the more language you had yesterday about, these states are sovereign, the essence of the state police power is to regulate this, regulate that. The more you were throwing it in the direction of the states, the more you were strengthening the argument of the Prop 8 people from the day before, yes?
Well, yes, and that's that's the case, it's also the case that it's useful in other issues, given the fact that federalism is essential guarantee of individual liberty. So I would have liked the argument to evolve differently, but I'm not altogether depressed about this.
All right. So then you say a respectable argument with which you disagree, but if you had to predict, and I told you we'd do this today, just on this one, on yesterday's argument, you're going to have for and Kennedy invalidating DOMA?
Yes. I would expect 4-1 and 4 decision where 4 liberal justices would probably in equal protection grounds as well as federalism grounds, perhaps, invalidate DOMA. But again, the equal protection argument bill would not be nearly as robust and across the board as the proponents of same-sex marriage by judicial fiat would like. And then you probably have Kennedy, who would only strike DOMA Section 3 on federalism grounds. So it would be the 5 votes for federalism. And that's most likely scenario.
And DOMA goes down.
Section 3 of DOMA goes down. Remember, what was not in play is Section 2 of DOMA that reinforces the ability of one state not to be bound under so-called full faith and credit clause by the marriage decision of another state.
That was my last question for this segment. We got about a minute and a half left. Give me your Massachusetts example and your South Carolina example here now. If DOMA's down, if a gay couple gets married in Massachusetts and goes to Mississippi, does it have to be recognized?
It does not have to be recognized, but very difficult questions for purposes of state law. Federal law. Whatever example, I think what for those who are interested in that sort of thing, the quickie Las Vegas divorce is out, certainly for some category of married people, because in a state that does not recognize gay marriage, there's no same-sex marriage, there's no such thing as same-sex divorce. So if you got married in Massachusetts and then moved to Texas or Mississippi, you want to get divorced, I guess you need to go back to Massachusetts. You cannot fly to Las Vegas.
That's for gay couples.
Right.
Straight couples can still do it, I guess. I don't know. All right, I understand. Yeah. That was a very interesting point yesterday you made about the quickie marriages, too, because you have to have a witness. This is the part of the state interest in this. That's that's one of the examples of it. We'll come back. David Rivkin will stay with us. Just one more segment. I want to ask him what he thinks comes of the 2 days of hearings, what the ultimate result will be. Best guess. If you have a question, good question, you can ask it concisely. Please call us at 866-680-6464. David Rivkin is a partner at Baker & Hostetler. Used to work at Justice and the White House Counsel's Office in Reagan and Bush. Stay with us. Stays with us. We're going to try to keep him. We'll see what his schedule is. A lot of questions for you, David. I'm going to ask folks to be brief and concise. And
Bill, I'll be happy to stay with you a little longer. Seriously, no problem.
Wonderful. Thank you very much. If you could give us till, say, 8:15, that would be great.
That's fine.
Thank you. Wonderful. Let's go.
I don't know if Chris told you, really beautiful job by Clement yesterday. I mean,
I gather.
It's a thing of beauty.
He's really good, isn't he?
He is excellent. And I'm not saying he's a friend of mine because he's a friend of mine. No, he is the best we got right now.
That's great. He argued technically for the House. Is that right?
Yes, something called bipartisan legal advisory groups, a group which is speaks for the House.
Okay, let's go to these are questions people are wondering what ifs. Let's go to Kevin in Minneapolis. Go ahead, Kevin, quickly.
Oh, hi. Actually, it's John. Long time listener, first time caller. But my question is, before the 14th Amendment, slavery was considered okay. And if the justices enforce the law, why don't we need to change the Constitution itself to make gay marriage okay?
Would it be okay to do a constitutional amendment if the judges change the law, have a sweeping decision?
Well, of course, one can have a constitutional amendment that would reshuffle the deck, so to speak, but I think the chances of having constitutional amendments are between slim to none.
Right. Thank you. Matthew is in Detroit. Matthew, go ahead.
Hi, I'm a pastor, and I'm wondering when you have homosexual groups challenge the church, and they will do that down the line, to the whole IRS. I know you know about that. Give me your opinion. Thanks.
Actually, it is a serious concern because in a situation where the federal government is held to have no legitimate interest in any marriage-related issues, I can see lawsuits that claim that benefits of a federal tax exemption cannot discriminate. Certainly in a state that allows same-sex marriages cannot discriminate and refuse to perform gay marriages. Now, the countervailing argument, of course, would be the freedom of religion. But it's not that far off. Not that far off as a possibility.
This would turn on a fairly sweeping decision by the court, though, right?
Even, Bill, if there's no sweeping decision, if it's a decision which says that the federal government absolutely can take no sides in this area, because remember, the tax exemptions don't come from the states. They come from the federal government. Okay.
But if the state had a law that allowed same-sex marriage, you might have that challenge in a church in that state.
Correct.
And it might prevail.
I hope not, but, you know, these things are evolving.
All right. Greg in Louisville says, okay, no DOMA. If DOMA goes down, go ahead, Greg.
Yes. Doesn't Section 2 of DOMA violate full faith and credit? Because it seems to me Texas should be required under the full faith and credit clause, and the try to stop that would be unconstitutional.
No, I mean, there are two things. First of all, the language of a full faith and credit clause already in the Constitution contains so-called public policy exemptions, so states are not obliged to recognize a contract made in another state if it's fundamentally against their public policy. But in addition to that, Section 2 of DOMA, because Congress can legislate in this area, specifically affirms the right of states not to be bound by marriages performed in states that have a different definition.
So I just want to rehearse this because I was unclear on this. You get married in Massachusetts, same sex. You go to Texas. Texas doesn't have to recognize.
Does not have to recognize your marriage at all.
I thought that's what DOMA was all about.
No, well, that was Section 2 of DOMA. Section 3 of DOMA had to do entirely, Bill, with whether or not you are eligible to receive various benefits under federal statutes that require. What the opponents of DOMA argue is that the federal government should be guided solely by the state definition. So if you're a same-sex couple in Massachusetts, you get federal benefits that go to married couples. If you're a married couple, if you're a same-sex couple in Texas that does not recognize same-sex marriages, you don't get the benefits.
Okay. Roger, quickly. Roger in Washington, D.C. Go ahead, Roger.
Thank you. Why is it not per se unconstitutional to recognize and offer benefits to same-sex married couples through statute, but not to heterosexual couples who are similarly situated?
Well, that's, of course, the argument made by the opponents of DOMA. The issue here is if this is not subject to heightened scrutiny, the federal government has its own legitimate reasons for uniformity in marriage definitions, and therefore in a situation particularly where the vast majority of states do not recognize same-sex marriage, this uniform treatment would have not violated equal protection laws. Again, it's a perfectly palpable argument.
Okay, Roger, okay. Put Roger back on, all right? Roger?
Yeah, I was thinking, in fact, of not so much a DOMA, but granting marital status at all, because what's a rational basis for saying gays should be allowed to get married, but not heterosexuals who live exactly the same way?
Well, that was, if I may, that's for Prop 8 the day earlier, because the federal government does not grant marital licenses. It's the province of the states, and the argument there is that as far as equal protection is concerned, the two sets of couples are not similarly situated, and there's no fundamental liberty interest as far as the due process is concerned in being able to force the society to change the institution, which is a fundamental difference from the case in which had to do with it's the Loving case versus Virginia, which had to do with whether or not people of different races could marry.
All right. I feel like baseball seems like batting practice. David's taking fastballs, curveballs, hitting everything out of the park. David will stay with us another segment. I got some questions. Stay with us, folks. It has been a remarkable 2 days with David, partner at Baker & Hostetler, served in the Justice Department, White House Counsel's Office. Again, David, I want to thank you so much for your generosity.
Always a pleasure to be with you, Bill.
Giving your time. And this is a good audience, too, isn't it? They know how to ask a question in a succinct way, don't they?
Correct.
We're very pleased. So good succinct answer. Correct. Riveting Rivkin. That's what the names are coming up to. That's what the audience is saying. Riveting. Let me ask you this. A couple questions from me. It seems unlikely to me. Does it seem unlikely you were going to have a Roe v. Wade type decision, big sweeping declaration?
Very, very much the case.
Okay, and that means that let's take four hypotheticals. Give me your guess where you think the court will come out. What does that mean to things like, I don't want to hire someone because I don't want to hire a gay in my classroom, the Boy Scouts, the churches question, which came up before. Where will that stand?
Not directly,
from marriage?
Right? Not directly in plaintiff's cases, but certainly in laws governing employment discrimination are already in place. Of course, the question to which it applies to groups like churches or Boy Scouts is a little more difficult. But I would say we're clearly moving in the direction as a country where there can be no legally defensible posture relating to employment or any other matters that are based upon sexual orientation.
So you couldn't discriminate in the Boy Scouts?
Well,
Boy Scouts a funny organization.
Yeah, Boy Scouts or Girl Scouts, as you know, they fought very hard and actually won, but it's a temporary victory. There's been a real campaign to defund them by a number of corporations, and I think their current policy is it's done at the local level. I would be surprised if in 5 or 6 years there are many Boy Scout troops left out there who do not allow gay Scoutmasters.
Okay, that's an interesting comment. Principal of a public school, I don't want to hire gays because I just don't think it's right for my boys growing. Not
survivable. Even now, it would be unlawful employment discrimination.
Religious school?
Tough. I don't know. I mean, the current administration is very, shall we say, relaxed, and that's a kind way of putting it about religious liberty, as we've seen with the contraception mandate. But that's something that my hope is will survive. The church that believes that this behavior constitutes a sin can hardly allow people who are sort of practicing that actively to be working for its educational institutions, despite the fact that education is presumably largely secular. But it's a tough call.
I don't want to strain the soup too thin, but can you make a distinction between hiring someone who is homosexual and saying, but no homosexual activity if you're in public about it?
Yeah, well, it's kind of a civilian version of don't ask, don't tell.
Yep.
No, I think that that would not be easy to maintain. But as I said, I'm not sure how it would be resolved. But you've chosen the most difficult balancing area here.
All right, and I'm off point too. Let's go back to the point, which is marriage. What do you think this court will do, and what will happen to marriage, same-sex marriage, traditional marriage in the states following this decision? Or give us what you think the 2 or 3 most likely options.
I would say the most likely outcome that Section 3 of DOMA, as I mentioned earlier in the show, goes down. It's severed from the rest of the statute. The rest of the statute survives. On Prop 8, my guess is that it would either be a decision that has to do with standing, namely the notion that the people who are defending Prop 8 not really have standing to do so. If that happens, it would it would result in a demise of certainly the Ninth Circuit decision and possibly even district court decision. And if a district court decision survives, that means that Prop 8 would be struck down only in the footprint of that district court. I really do not, the outcome I don't see at all is 5 votes in favor of the proposition that same-sex marriage is constitutionally compelled either under due process clause equal protection clause. Going forward, very briefly, Bill, I think the vigorous debate would continue. I frankly don't know how many states are going to go join the other 9 that have legalized same-sex marriage. Very important for proponents of both positions to wage the debate in respectful fashion. And for those who care passionately about traditional marriage, do not try to pass legislation and have debates that manifest animus, that manifest hatred, because that is going to be used by those who challenge it to sort of underscore how irrational and biased the behavior is. So rational arguments, social stability, preservation. I mean, my favorite argument, of course, is the one I made yesterday, which is, look, marriage has to mean something very concrete and very exclusive. If a variety of arrangements become acceptable as marriage, then marriage means nothing.
Yeah, Roberts had an interesting point, didn't he? Was it yesterday or the day before, where he said when marriage was established, folks didn't say, all right, here it is, and by the way, we're going to exclude homosexuals.
Right. That was Proposition 8. He was sort of pushing back against this notion, which has been pushed. I mean, one thing I would recommend your listeners check out today's Wall Street Journal editorial, which begins in a beautiful prose, I think, in the second paragraph, which makes the point that the liberal establishment is trying to portray opponents of same-sex marriage as bigots. But President Obama himself opposed same-sex marriage as recently as a year ago. So is he also a bigot?
No, that's right. All right, if it stands, if Prop 8 goes down in California on grounds of standing, or that's the most likely ground, I guess, what happens in the other states then?
States are free to continue. Yeah, I mean, to put it broader, forget the details about standing. I think that the Prop 8 decision, whichever way it comes out, will be largely limited to California, so there would not be one-size-fits-all 50-state solution. Do
you see, not as a lawyer, a legal expert, which you obviously demonstrated over the last 2 days, you do it every day, but as a citizen, because that's a question I asked Tony Perkins, the train seems to be going in one direction. Do you see, given Alito saying it's so early, 10 years, 20 years, 30 years, the experience of a free people with same-sex marriage in some states, that we would learn something? It's conceivable that people would decide to change their minds on this?
It is entirely conceivable, and that's how federalism is supposed to work. Things in life should not be a one-way ratchet. You can adopt a policy, see if it works. If it works well, you continue on that path. If it does not work well, you don't continue on that path. But again, at the risk of sounding like a broken record, and I've heard Mr. Perkins a number of times, we got to broaden the debate beyond the discussion about childbearing and children, and again look at the other issues in terms of stabilizing role of marriage defined. And remember the point we discussed yesterday. Look, you cannot have any institution that's infinitely inclusive, because it means nothing.
Yeah, the institution then means
has to be somewhat exclusive.
Yeah, I suppose one of the arguments is that this will strengthen marriage, and I suppose data will tell us that in 10 or 20 or 30 years.
Data will tell us, but again, to me, I mean, if you think about it as an infinite variety of claimants, the fact that the first set of claimants, same-sex couples, if they get their claims satisfied, we have to ponder what does it mean for the next and the next set of claimants. And, to revise my hypothetical about the 10-year marriage, I don't know if you're a fan of A 7-Year Itch, the movie.
Yeah, sure.
I mean, it's not to be flippant about popular culture here. I can see a lot of people coming in and saying, we want to have a temporary marriage that expires by operation of law.
Yeah.
What possible basis? And that would be in some ways horrible, and some of your listeners may think, well, how is it bad compared to same-sex marriage? Well, the reason it's bad is because it completely destroys the core of marriage, which is a lifelong commitment. Of course, people get divorced, but that's an exception that still keeps the rule viable. But if you're going to have temporary marriages, marriage means nothing.
Yeah. Is this the way the world's going, same-sex marriage?
I'm afraid that well, you know better than I do that the popular culture is unfolding in bad directions, and the law, unfortunately, is not helping very much.
Okay, we shall see. We shall live. We shall learn. Hopefully we learn from our experience. We've certainly learned from you. David Rivkin, thank you very, very much.
Always great to be with you, Bill.
Much in your debt. Thank you very much. Boy, there's a lot to chew on there, guys.